Chairman, and then we will have public comments. So let's go ahead with David. You want to?
Sure. Yeah, thank you.
Yeah.
Thank you for the opportunity to address the board. I have reviewed, again, all of the legal opinions. There's 3 of them. I reviewed Mr. Tiernan's recent 3-page document. I've looked at the petition, the 68 petition, the reorganization documents, and refamiliarized myself with the various case laws that have been studied and considered. So one thing I think I'd like to start with is just to merely point out, many of you know this, but I certainly didn't until recently. The Service District receives approximately $600,000 a year. It varies. So for example, in 2015 it was 590, 2014 it was $654,000, 500,000 in 2013, 489 in 2012, and 492 and change in 2011. In the last 20 years, we've received approximately $9 million of tax money for security and maintenance of the road. We have many, many bridges in this community, as we all know. When those bridges need to be repaired, they're very expensive. It was understood and recognized 50 years ago and before then that these roads are going to take a lot of money to fix, and decisions were made to access tax money. And the only way you could do that is by forming the service district. And it was specifically contemplated at that time that this money was needed for security and maintenance on an ongoing basis, and that there was no other way to get it. Now I'm going to quote from the petition, again signed by Mr. Tiernan Sr. One of the things that says that the only method to procure sufficient consistent income to support this proposal is through and by means of a tax assessment. So decisions were made 50 years ago. We needed this money. So we have to, I tried to pose some questions that I think will solidify the issues. How can we be entitled to $600,000 a year in tax money, public money, to maintain our private roads in the absence of public access? So we're going to take $500,000–600,000 a year. We're going to maintain our private roads and not let anybody in, not let any taxpayers in. People that we get the money from, we're going to exclude them. And by the way, how's the sheriff going to do that? How are they they do a great job, but how are they going to, somehow have this presence of mind to know who lives here, who doesn't, barricades, blocking? What are you going to do? It's almost impossible to consider that. So leave that off to one side. Here's another one. Why can we use public money for security in this community if it's just for private use? So again, we're going to have public money for security to block out public people. We're going to have public money for private roads and not let people use them. So if you contemplate that, then you say, well, what do we really have? Are we public or private? I mean, they're private roads, but they're subject to public use. If these are just private roads, not subject to public use, then what's the point of the DCSD? The DCSD has power to maintain these roads by virtue of a petition that grants its tax dollars year in and year out. If these are purely private roads, we don't need the DCSD, because the DCSD is no longer going to maintain the roads. So it's very inviting, and I recognize that there's a dispute. There always will be a dispute over whether people like bikes or not. But when you go back to the documents, it is absolutely unequivocal that we made a deal, so to speak, in 1968 and before. And I'm going to review the 1952 documents, and I'm virtually positive that the 1952 documents speak of a public right-of-way to these roads. I haven't seen them yet, but there's a suggestion right here by Mr. Tiernan in 1968 that indicates that. And I'm going to read back to the petition. Again, this petition is June 19th, 1968. The area is subject to extensive acts of vandalism and frequent burglaries. This was the argument in favor of security. With few exceptions, the roads within the proposed district are private in nature, but subject to a right-of-way reserved to the public. Now this was the petition. This was before the election, before the reorganization was passed by the Board of Supervisors, and it was stated in here at the time of the position that these roads were subject to a right-of-way reserved to the public. Furthermore, on this whole issue of can bikes come in and it's their recreation, they shouldn't be here and so forth, was that ever contemplated in the past? Well, it absolutely was. Here, and I'm reading again, the Tiernan's petition. Since the area is primarily residential and recreational, the risk of personal injury and property damage due to vehicular traffic is inordinately high, as they were advocating for security money. It was acknowledged 50 years ago that these roads are open to the public and open for recreational uses, whatever that is. People riding around, looking around, bird watching, whatever you want to do. Nonetheless, they're open for that reason. Then again, as I said before, the only way to get that money is by means of a tax assessment. There were 4 things that they asked for. Looking at my time. And it was real simple. We asked for street lighting, we asked for maintenance equipment for the police, for the police to be able to secure the community, and this opening, closing, widening, extending, straightening, surfacing, resurfacing in whole or part any of the street or road which is subject to a right-of-way by the public, in black and white language. Now, 2 things here. If we had changed that language, let's just imagine it said something else. The opening, closing, widening, etc. of any street, and left out subject to the public right of way, that would have had a different meaning. So if we would have said we're petitioning to get public money to maintain our rights, our private roads, and we're going to exclude the public, do you actually think we'd have got that money? Do you actually think that this would have become a district? They'd have said, are you kidding? That doesn't pass the laugh test. Okay, so why would we give you public money year in, year out and let you kick people out? It's ridiculous. Okay, so furthermore, again, I recognize people have different opinions here, but this is, this is a public entity. We're trying to do the right thing. So you go back to now I understand that there's a quote affidavit out there that says that the document, I gather, means something different than what it says. We said certain things, but we didn't really mean that. And that is somehow this affidavit from Mr. Turner is going to be significant and meaningful and change it. Well, it doesn't. It won't. That's not admissible evidence in any court of law. There's something called parole evidence for that reason. If I enter a contract with you and I say I'm going to sell my house for $1 million to you and we're going to do it tomorrow and we sign it all up, I can't come in the next day when you say give me my $1 million and say, no, I didn't really mean that. And I'm going to testify and I'm going to sign a declaration that says I meant something different than what I actually put in black and white in that piece of paper. This is what they call an integrated document, that it is fully legal. It went through the supervisors, it went through an election. Why do you think it went through an election? Because when you just start tapping the public till, the public's got to let you do that. The public allowed us to tap the till under one circumstances, and we promised to do that. And what was that promise? You can use our roads. Okay, so we can't go back on that. Furthermore, this whole business, opening, closing, so the argument is we have the right to close roads. What does closing mean? The law, there's a case on point. Been cited in the legal opinions. It's not news. Districts cannot restrict the use of roads. You can close a road to fix it. You can close a road to put the equipment in there. You can even close a road if you think that it's so unsafe that you just can't have that road anymore. You can eliminate it, no road anymore. But you cannot restrict it. There's cases on point to that effect. So when we go down these things one by one by one, the money that we receive, the history of it, the 50-year history of it, the legal opinion after legal opinion that addresses this, that makes it very clear that at the very least this is going to be a very difficult task, and that if we try to restrict it, we're going to be sued, and it's going to be a class action because there's a group of people that are going to want to come in and say we have these rights. So even if we go out and try to get funding for another legal opinion, what do we have there? We got 3 opinions that says, you're going up the creek if you do this. Get one more, even if it categorically disagrees. What do you got? You got 3 lawyers saying it's this way, you got 1 more saying it's another way. You've got nowhere. You have not advanced the ball at all, except you spend a lot of money. So my vote is, you know, let's keep working on the security and keep making people enforce, you know, have our laws enforced, and just like the rest of it, drive cars and so forth. But the idea that we can
Okay.
limit public use is it. Thank you.